Welcome to DBD Homes. You're here to sign your lease today, so let's get started. Number one is your basic provisions. It goes over the provisions of the lease. 1.2 is the parties. That's you. DBD Homes is the property management company and the landlord. Our information as well as your information are listed there. Please initial. 1.3 is the property that you are looking to rent. Should have the address there. Please initial below that. Understand that there is no guarantee for a dry basement. The use of a dehumidifier is strongly recommended. And 1.4 is the term. This goes over the term of the lease. It can be 6, 12, or 24 months. Whatever your term is should be listed at the top of this section. Today's date is the commencement date. That's when it begins, and the expiration date is listed as well. Please initial below that. Number 2 is monetary obligations. That's how much rent is due at the beginning of each month. Tenant shall be given a grace period to make all rent and other payments due without penalty for lateness by the close of business on the 5th day of each month. That means you have 5 days to get your payment in before we can assess a late fee. Late fees are 10% of your rent due. There is also a return check fee of $30 if a return check is applied. Please initial below that. 2.2 is early termination fees. Should tenant terminate or cancel lease before the completion of its initial 12-month term or otherwise be in default of his or her payment obligations, he or she becomes liable as a liquidated damages payment to pay the remaining balance of all amounts of rent or other payments due, such as utilities, for the remainder of the term. Landlord should make all reasonable attempts to mitigate the damages required to the extent of law. Should the tenant terminate or cancel the lease at or after completion of its initial 12-month term or otherwise vacate the property without giving written notice, the tenant shall be liable for an early termination fee equal to 1 month's rent. 2.3 is a security deposit. The total security deposit at the time of execution of this lease is whatever the amount that you paid for your deposit. We will hold the security deposit for the term of this tenancy without interest. Upon termination, reserve the right to use the security deposit for portions thereof to cover any damages for the performance of this lease. Included but not limited to cleaning, removal of property, repair of damages, late fees, return check fees, unpaid utilities, attorney fees, and collection costs. The security deposit cannot be applied to the last month's rent. 2.4, special payments and credits and maintenance credits. Landlord, at his own discretion and in expectation of full observance of the tenant's obligations under this lease, may provide special payment credits at commencement date. These credits include but are not limited to uncharged rent for a period of days and other move-in special offers. When appropriate, the landlord shall grant the tenant payment credits, maintenance credits, in lieu of the tenant's payments for maintenance repairs or other property improvements. These maintenance credits shall not be granted unless repairs or improvements were approved by the landlord in advance or as necessary in an emergency situation. The tenant is responsible for maintaining receipts for all such repairs and improvements in proof of claim. No cash or refund shall be granted for any earned maintenance credit. The amount of credit shall not exceed $200. On to page 4. 2.5 Utilities. Tenant shall provide account numbers for all utilities which will be assumed under this agreement. The tenant shall keep these utilities on at all times at appropriate levels. Tenant shall pay security deposits necessary for utility hookups and pay all utility bills as they become due. Any portions of utility bills sent to DBD for service after commencement date shall be added to the tenant's next month's ledger. Please note the utilities required for your unit below and then initial. 2.6 Pet fees, tenant obligations. Tenant shall pay a one-time non-refundable pet fee of $200 per pet and an additional pet rent of $20 per month. Tenant shall not keep pets on the property unless he or she obtains prior written consent from the landlord. Failure to notify the landlord is a $250 pet non-notification charge in addition to pet fee and monthly pet rent. The following dog breeds will never be approved: Pit Bull, Rottweiler, Doberman, Chow, and German Shepherd. The landlord reserves the right to reject any dog even if given prior approval. Tenant shall be financially responsible for all damages to the property caused by his or her pets. Upon vacating the property, the tenant shall pay either an independent professional service or landlord to have all the carpets on the property professionally cleaned and defleed. The tenant shall exterminate for fleas twice during each 12-month period and maintain proof of such action. Tenant is expected to abide by all rules and regulations set forth by Animal Care and Control, and we, the landlord, have the right to call Animal Care and Control for pickup of unleashed or unmanaged pets and impose a reasonable fee for doing so. Pets must not disturb neighbors or other residents, regardless of whether the pet is inside or outside. The designated area for defecation and urination in the house is the backyard only. All waste must be picked up daily. No dogs of any kind are permitted on upper units of multi-unit properties. Please initial below. 2.7 Keys and locks. The tenant shall be charged $20 for a key replacement or opening doors if a tenant is locked out. If a lockout needs to be replaced for any reason, there is a $40 lock replacement per lock. Tenant shall not place any additional locks on any door without the landlord's written consent. Page 5, 2.8, fixtures, appliance installation, carpets, woodwork, plumbing, etc. Tenant shall not install any equipment requiring changes to the physical structure, electrical, or plumbing system without landlord's written consent. For any appliance, monthly utility, or service provided by landlord, tenant shall not install any related appliance without landlord's written consent. Should tenant nail or cement any kind of carpet or other covering to any floor or install any other permanent fixture on the property, it becomes the sole property of the landlord. Under no circumstances shall tenant ever paint, damage, or alter the stained woodwork on property. Tenant shall be liable for all plumbing stoppages and sewer cleaning services during his or her tenancy. Tenant shall not put or pour any debris, grease, paper towels, Q-tips, tampons, feminine wipes, baby wipes, or any other inappropriate matter into the sink, drains, or toilets. Should tenant be in default of any of provisions of this section, tenant shall be charged a $250 non-compliance fee along with the entire bill from the professional service company to clean or repair any damage resulting. Please initial below. 2.9 missed appointment fee. If you miss an appointment, there is a $50 trip fee. 2.10 indemnification. Tenant shall indemnify and hold harmless landlord and DBD for all fines or expenses incurred or paid by landlord or DBD, especially to any public agencies on behalf of tenant, due to tenant's own fault or neglect. Tenant shall indemnify, defend, and or hold landlord and DBD harmless for any accident, claim, damage, liability, or injury suffered by tenant or tenant's personal property arising from or connected with tenant's occupancy, control, or use of property, except for landlord's willful acts of gross negligence. Please initial below. Number 3, landlord rights and remedies. 3.1, landlord's rights and remedies. 3.2, partial payments, attorney fees, and other remedies. The acceptance by landlord DBD of any partial payment of rent or other payments due under this lease shall not affect the obligation to pay the balance of that or any other unpaid amount due. In case of tenant's default or breach of any provision of this lease, tenant shall pay all responsible attorney fees and court costs incurred by the landlord or DBD in pursuing remedies to cure such default. Continuing on page 6, any right or remedy is taken by landlord under a provision of this lease or as provided by law shall not disparage any other right or remedy landlord DBD may have under this lease as provided by law. Continuing on page 6, 3.3, assignment or sublease is prohibited. Tenant shall not assign, mortgage, encumber, or transfer this lease in whole or in part, or sublet the property, nor grant a license or concession in connection therewith without landlord's written consent. 3.4, landlord's right to enter. Landlord DBD shall have the right to enter upon any part of the property at any reasonable time for reasonable inspections, repairs, improvements, promised services, or to show property to prospective tenants or buyers. 3.5, landlord's right to cure tenant's default. Should tenant fail to perform his or her obligation under this lease, landlord DBD may perform such obligations on the tenant's behalf. 3.6, landlord's right to terminate. Landlord shall have the right to terminate this lease immediately for good cause, upon which landlord may give tenant immediate notice to vacate property. Good cause includes, but is not limited to, failure to make timely rent or other payments due, illegal, dangerous, or wasteful activity, abandonment, tenants filing for bankruptcy, unauthorized lease encumbrances, willful failure to cure a default under this lease, and violations of this lease which gave notice of liability for eviction. Also, should property become damaged, destroyed, or condemned to the extent that it is no longer habitable, the landlord may terminate this lease. Nevertheless, landlord at its option shall have 30 days upon receiving written notice of such damage or destruction to restore property to at least its condition on commencement date. If the property is so restored within the 30 days, the remainder of the provisions of this lease shall continue in effect, except that all rent payments due for the period when the property was not habitable shall be abated on a prorated basis. 3.7, notice to default, other notices. At landlord's sole discretion, landlord DBD reserves the right to send an optional notice of default as a courtesy reminder of rent or other payment past due or any other default under this lease in lieu of beginning a court eviction process. A notice of default may be given to tenant by mail, by hand, by attaching it to the door of the premises, or by any other reasonable method. This is in addition to any other notice required by law. 3.8, storage of property. This lease does not convey any special right of storage, and landlord DBD shall not assume responsibility for any loss or damage for any personal property stored by tenant on property. 3.9, abandonment of property. Should tenant leave property unoccupied for 15 days without having paid rent in advance for that month, or while owing any back rent from previous months, landlord shall have the right to take immediate possession of property and to bar tenant from returning. 3.10, tenant's personal property recovered by landlord. After tenant has voluntarily vacated the property, any items of personal property left shall be considered abandoned. The landlord has the option to either immediately dispose of that personal property in a manner of its own discretion, or to store it for up to 30 days first at the tenant's expense before such disposal. In the event that the landlord files a claim for possession of property with the appropriate court having jurisdiction and obtains possession through a writ of restitution, landlord shall have the right to remove all tenant's property. Landlord shall store items that appear to have reasonable value under a lock and key for a period of 14 days or as ordered by the court. If tenant makes no claim to those items within the allotted time, the landlord shall assume those items are of no value to tenant. Landlord shall not be responsible for theft or damage of personal property incurred after such eviction notice has been posted. Please initial on following page 7. Page 7, number 4, other tenant obligations. 4.1, property maintenance. A, general condition, tenant shall maintain and return property in condition as clean and good as commencement date. Tenant shall use equipment, electrical systems, plumbing, sanitary systems, heating, ventilation, and air conditioning systems located on property only in a reasonable manner. Tenant shall be solely responsible for and shall pay landlord immediately for all damages to property except for normal wear and tear caused by tenant. Examples include any broken windows or battered doors. B, pests. Landlord shall not be liable for the presence of insects, bugs, or vermin, if any, on property, nor from damages suffered therefrom. See Section 5.1 Delivery for landlord's obligations regarding pests. Tenant shall be responsible for acquiring appropriate professional pest extermination services as necessary, except that tenant, with written notice, may direct landlord to hire such services instead. Tenant shall be responsible for all costs, such as to be added to the next month's rent payment. The tenant has the right to have the property professionally inspected for pests, including bed bugs, and hereby acknowledges at the time of occupancy that there was no issues with pests of any type. Please read the addendum to the lease. C. Carpets. When vacating the property, tenant shall contract with an independent professional cleaning company service for the cleaning of any and all installed carpets located on the property. Tenant shall offer landlord DBD proof of such service upon request. D. Painting. Tenant shall not paint or disturb any painted surfaces or make other alterations to the dwelling unit without landlord's prior written approval. Tenant shall notify landlord and agent in the event there is any chipped or peeling paint in the dwelling unit. Tenant, at his or her own expense, shall restore paint to its original color upon vacating property without the written consent of landlord DBD for another arrangement. E. Bulbs and filters. Tenant, at his or her own expense, shall maintain light bulbs, air conditioning, and furnace filters where applicable, at least 2 times per year. F. Garbage. Tenant shall maintain the property grounds free from garbage, litter, and other unsanitary waste. Tenant shall maintain all garbage and recycling receptacles in an orderly manner at all times on the side of the principal structure, except that such receptacles may be placed for curbside pickup from noon the day before the scheduled day pickup to noon the day after the scheduled pickup day. At no time shall the placement of such receptacles impede pedestrian or vehicular traffic. Tenant shall not dispose of motor oil, antifreeze, car batteries, or other toxic materials with garbage and or recycling collection. G. Lawn and walk care. Tenant is responsible for exterior maintenance, including lawn mowing, snow removal, cleaning the gutters on the house and garage if applicable, and cleaning tree debris. If local neighborhood code enforcement places a notice on the property for any violation that falls under tenant's responsibility and the tenant fails to comply, they will be responsible for any bills incurred for the work completed or penalties. Tenant shall mow lawn and rake leaves as appropriate and otherwise provide for clean, trim grounds. Tenant shall clear all sidewalks and walkways of snow accumulation in accord with local law and clear gutters of leaves and debris. No structures of any kind may be mounted on the house, roof, and permissions must be obtained before modifications are made to the house or roof. H. Signage. Tenant shall not affix to or upon the exterior of any building or on the grounds of the property any sign, insignia, or decoration without landlord's written consent or except as required by law. I. Egress. Tenant shall not obstruct in any manner any means of coming or going from any portion of the property. Continuing on page 8. J. Flammable or combustible materials. Tenant shall not have or store flammable or combustible materials on property in an amount considered dangerous by law. K. Access to repairs. Tenant shall grant landlord DBD access to any part of the property at all reasonable times to exercise rights listed in section 16, landlord's right to enter. L. Indemnification for all costs incurred by landlord to enforce default in this section. Continuing on page 8, 4.2, mold, moisture, and dust. Tenant shall take all necessary measures, including appropriate climate control, to prevent and retard mold accumulation on dwelling units of property. Regardless, the tenant shall keep dwelling units free from any mold that does accumulate. Tenant shall dust any dwelling unit on a regular basis and remove visible moisture accumulation from windows, window sills, walls, floors, ceilings, and other surfaces as soon as practicable. Tenant shall be solely responsible for all damages to the dwelling unit and personal property, as well as any injury to tenant resulting from the failure to comply with the provisions of this section. Please sign below. 4.3 Smoke detectors. In accordance with U.S. Fire Administration recommendations, the tenant shall check smoke detectors property at least once a month and replace smoke detector batteries at least twice a year to ensure proper functioning. The tenant shall immediately notify DBD if any smoke detector is not functioning properly. In the event a smoke detector is not functioning or tenant is unable to replace the batteries, the tenant shall notify DBD, upon which DBD will resolve the issue. Landlord DBD may also inspect detectors during routine inspections, replacing or repairing those found not to be functioning properly. Please sign below. 4.4 Noise and nuisance. Tenant shall not make or permit any loud, raucous, improper, unreasonable, offensive, or unusual noise or disorder on or near property that violates a local noise ordinance or disturbs, injures, or endangers the peace or safety of others. Tenant shall turn down volume of electronic or similar devices after 10:30 p.m. The tenant shall not create a nuisance situation by disturbing, annoying, or inconveniencing others. Point 5, attractive nuisances. Many objects have the potential to draw a child onto a property. Some of the most frequent seen that can or have caused serious injury include trampolines, construction material, swimming pools, ramps, treehouse ponds, playscapes, play sets, and fireworks. Tenant shall not use or permit the use of any type of consumer fireworks except as permitted by law. Tenant shall not use or permit the use of any swimming or wading pool on property with water at a depth greater than 11 inches, unless with DBD's written permission. The tenant shall also strictly monitor minor children for activities covered in this section and ensure they comply with any and all federal, state, city, local laws, ordinances, regulations, and mandates. The tenant must also personally insure against any and all liability regarding the above attractions. On to page 9, 4.6, illegal activity. Tenant shall never participate in, allow, or operate any illegal, criminal, or drug-related activity on property. Any such activity shall result in immediate termination of this lease and eviction. 4.7 Emergencies, emergency and non-emergency repair. After making any appropriate 911 calls, the tenant shall immediately report to the office all emergencies and emergency repair needs at the phone number listed, leaving a phone message if no staff member answers the call. Such emergencies include but are not limited to flooding and other water issues, heating loss issues in winter, fires, broken windows, serious bodily injury, and security situations. In the event that the maintenance department is not available and maintenance emergency, as described above, occurs, the tenant at their discretion may contact an outside company for repairs. The landlord will reimburse up to $200 when a legitimate receipt is provided. The tenant shall notify DBD of other non-emergency issues and repairs in an appropriate manner. Please note, when requests for service are made, it is automatically assumed that the resident will allow maintenance access during regular business hours without further permission. Pets must be kenneled or otherwise restrained or confined. If maintenance cannot access the property due to tenant neglect, a $30 maintenance fee will be charged. 4.8 Renter's insurance. Tenant shall notify DBD by choosing one of the options below with regard to his or her current status of renter's insurance or other general liability insurance coverage. Tenant shall immediately notify DBD in writing as to any changes thereto. Should tenant fail to maintain renter's insurance at any time, tenant shall be solely responsible for all liability, claims, damage, theft, and vandalism to property. tenant's person and tenant's personal property from any cause whatsoever. Please initial below. Section 5, other landlord obligations. 5.1, delivery. Landlord shall deliver property to tenant in a safe, clean, and habitable condition in compliance with all health and housing codes on commencement date. All smoke detectors shall be checked at the time and replaced if not functioning properly. The landlord shall hire professional pest extermination services to inspect the property on or shortly before the commencement date and cleanse the property as necessary. Nevertheless, if landlord for any reason cannot deliver possession of property to tenant on commencement date, this lease shall not be void or voidable, nor shall landlord be liable to tenant for any loss or damage resulting therefrom. But all rent shall be abated during the period between commencement date and the date landlord actually delivers possession of property. Moving on to page 10, 5.2, repairs. After written notice from tenant, DBD shall make all repairs necessary or reasonable as determined by DBD to maintain the following property items: exterior and structural walls, structural floors, foundations, roofs, gutters, exterior downspouts, driveways, walkways, and heating appliances. The landlord shall also maintain the following appliances as marked below. The tenant may use other appliances provided but not listed. However, the landlord shall not be responsible for maintenance or repair. Tenant shall leave all appliances provided by landlord on property when vacated. Tenant's theft of any appliance will be prosecuted. The landlord or DBD shall place any requested maintenance, improvement, or repair into a queue based on its importance versus all other outstanding job demands. Non-emergency repairs shall be addressed as they come to the forefront of the list from Monday to Friday during regular office hours. Please initial below. 5.3, common areas. If property contains any area common to other tenants subject to other leases, landlord shall make all reasonable efforts to maintain such areas in a clean and property condition. 1. Parking. Unless specified or handicap accessible, off-street parking is for tenant use only. Guests or visitors are to be directed toward street parking. By initialing below, you acknowledge the terms in Section 5. Section 6, required disclosures. 6.1, lead warning statement. Housing built before 1978 may contain lead-based paint. Lead from paint chips, and dust can pose health hazards if not managed properly. Lead exposure is especially harmful to young children and pregnant women. Before renting pre-1978 housing, landlords must disclose the presence of known lead-based paint and or lead-based paint hazards in the dwelling. Tenants must also receive a federally approved pamphlet on lead poisoning prevention. Please continue on to page 11, where you will initial that you understand this section regarding lead-based paint. Section 7, miscellaneous provisions. 7.1, A, headings. The article and section headings contained in the lease are for reference purposes only and shall not affect the meaning or interpretation of this lease. All references in this lease to such headings, for example, the words "see also section blank," are for reference purposes only and shall not affect the meaning or interpretation of this lease. B, signatures. Any signature on this lease may be a facsimile or digital signature. C, entire agreement. This lease constitutes the full and complete agreement of the parties. Any other prior oral or written agreements or understandings are superseded today. D, severability. Each provision of this lease is severable. The invalidity or unenforceability of any provision shall not impair the validity or enforceability of any other provision. E, validity as to other parties of interest. This lease shall extend to and be binding upon the heirs, personal representatives, successors, and assigns of the parties. This provision, however, shall not be construed to permit the assignment or encumbrance of this lease. F. Choice of law. This lease shall be governed by the laws of the state of Indiana, excluding its choice of law provisions, even if actions relating to this lease touch upon other jurisdictions. G. Venue. Any litigation relating to this lease shall be brought and venued exclusively in Allen County, Indiana, and no party shall object to that such venue in inconvenience or improper. H. Amendments. Except for as provided for elsewhere in this lease, any amendment to this lease shall be in writing, signed by all parties in order to be enforceable. Please initial at the top of page 12. Moving to page 12, section 8, acknowledgement and signatures. 8.1 acknowledgement. With his or her signature below, tenant acknowledges that he or she has had an ample opportunity to review this lease, including all attachments and addendums, and have it fully explained, that all questions about this lease have been answered, and that he or she fully understands all the provisions of this lease and the obligations and responsibilities of each party as spelled herein. Tenant further agrees to fulfill his or her obligations under this lease in every respect, or else potentially suffer the full legal and financial consequences of failure to fulfill them. Tenant hereby acknowledges receiving a copy of this lease and all required disclosures. 8.2 is signatures, so you'll initial below here. And that concludes your DBD lease. Congratulations. We're very happy to have you as a part of the DBD Homes family.